Let a review.
Next monthly list.
May I have lordship's time on what needs to be changed in this one? And also my senior who was appearing, his name is not big.
What word is to be changed?
Can you have a look paragraph, please? Only one word, because from that lordship reasoning is started. The ordering portion. I have given mentioning a notice it can have lordships as bolte din present application the writ petition such and such writ petition had a lease for 30 years in respect of 5 sites. Now, if lordship takes the quotation portion thereafter, lordship will find from the order on behalf of such and such is qualified term of lease granted to the petitioner was for 10 years. So instead of 30, that should be 10. That is the correction.
It's a pending line.
That is the only thing. And Malad, my senior's name is not included in the order. If the matter can appear to tomorrow,
record name is also not appearing.
But these are submissions. These are not findings of the court. You please see para 11.
Up to 11.
No. Correction. Just see.
And then, Malad, if it is my submission, that has to be changed. Just 10, 30 instead. If it is submission, then also my submission and gone incorrect.
This is your submission.
No, it's according to us, Malad, his lordship reasoning starts from here. Because he submitted Mitro, Malad.
When you file an application, what can be done? If that is the issue, then you file an application. What can be done?
It can be, Malad, appear as to be mentioned and one word can be corrected.
He is objecting. He says without application, it should not be done. According to us, we have recorded the submission of the. That's not our finding portion. Our findings come much later.
Lordship.
So, and as regards Mr. Mitra's name, it appears in the body. So why do you want to unnecessary? Pointless. Let's call the list. Call the list. Call the list. Call the list.
Item number 2.
It's a volume of judgment and it's a very important judgment. It's how the everything will be changed for most of the person. Okay. The doctor rightly pointed out the issue.
Well, the hearing of the main matter is necessary. What the hearing of the main matter is necessary.
This is to be mentioned. What is this? Top. Yes.
Matter is related to the prayer for compassionate appointment and pensionary death benefits to the illegitimate child of the.
Oh yes, we had asked you to come back with instructions.
Kindly see. The rule 105 of the DCRB rules. And amendment thereof on years of November 1997, that is at page 42. Or the book I have already handed over to your lordship.
No, what happened? What is the position?
So long first slide is there, first slide we get the heading. Amendment but second managing body on a kindly see that.
Then you file the opposition. Let them see, have a copy, then we will see.
In the meantime, kindly some interim protection, my lord.
Heard learned advocate.
Claim of the children. Can that be
Call the next.
Item number 3.
None appears.
My lord, I beg to appear, my lord. My lord's display is not working. That
Oh,
my lord,
yes, tell us. Give it. Who is for the state?
Lord, I have informed Mr.
Who is for the state?
My lord, Mr. Tapan Kumar Mukherjee, AGP is appearing, my lord. I have served, my lord, service. I have informed also served. And only to fix up, my lord, time and an authority. বুঝতে পারিনি তো ওই জন্য Yes, Mr. Tapan Mukherjee is appearing, learned senior AGP, my lord. Yes. ডিসপ্লেটা কাজ করছে এবার
হ্যাঁ আমি আছি
Yes, my lord. Interest, my lord, 6%.
Yes, till date of payment. So what is what?
My lord, the difficulty is, my lord, if they do not pay, my lord, it would be difficult to, my lord, to come up in contempt because, my lord, since, my lord, no time limit is fixed.
If
that is,
your understanding, then we don't have anything to
my
say.
lord, may I submit, my lord, subject to
Yes.
correction.
No,
my
if
lord.
that is your understanding, then we have nothing to say.
My lord, I find one judgment of Honorable Supreme
Yes.
Court, and relying that, my lord, other High Court also passed order that contempt is not maintainable. That is, my lord,
Let us see.
my lord. If the time limit is, my lord, subject to correction, my lord.
No, let us see. You have worked it out. So where is the question of correction?
My lord. This is the Supreme Court judgment, and my lord, this is the Karnataka High Court judgment, my lord, on the same point.
Which paragraph?
7, my lord. No. And relying on that, my lord, Karnataka High Court Division Bench also hold, my lord. Para 7, my lord.
বল সাইটেশনটা বল বোর্ডে
1984 AIR SC 1264.
Then let them file a reply. We'll see.
My
File
lord,
opposition.
the matter will be, my lord.
You want to keep it pending, then what can be done?
My lord, kindly, my lord,
What do you mean? Without giving them opportunity, we should pass the order. Please try to understand. We are not saying that you are wrong or right. But if we have to consider this with reference to judgments, then let them file a response. We can't pass an order like that. What has been done in the meantime? What is your instruction?
It's under process, my lord.
Huh?
It has been communicated, it's under process, my lord. Right now, I won't be able to see the exact position. It has been communicated.
So you take instructions. We'll see. It will come back after the court reopens. Let the learned
Apprehension, I do not know. Why he's so apprehensive about it? We do not know. Matter went up to the Supreme Court. Things have been settled down. What is
well, the difficulty, my lord.
All right, so let us see. We understand your anxiety. We understand your anxiety.
Yes, my lord. Interest is there so long the principal is not given, my lord.
He's sort of apprehensive, the ball will again roll on. Again, you have to go to
And
the
my lord,
tribunal.
and
That is
and
what
my
he's
lord, the
apprehensive,
difficult,
perhaps.
my lord, the
Perhaps.
difficulty I find, my lord, the other judgments of single bench, honorable single bench of other high courts, relying on this judgment, my lord, they say, my lord, the not only the contempt, subsequent writ petition has not been, will not be mentioned. My lord, that is why, my lord, yes, my lord, grateful, my lord. If the my lord comes with instruction, every purpose will be served. Grateful, my lord.
Item number 4,
My lord, service may be kept on record. Grateful.
Item 4, my lord, I beg to appear for the petitioner. This is my application under Article 227, praying for my lord direction upon the administrative tribunal for expeditious disposal of my application, my lord, pending since 2024. Why I have come up, my lord, I have challenged an order where, my lord, my prayer for my lord compassionate appointment was turned down by the authority concerned on the ground of age bar, considering my age on the date of order passed, on the date of order, but not on the date of the application. That is what I have challenged before the administrative tribunal, my lord. My present age is about 56 years. So that is why, my lord, I am beseeching your lordship, my lord, kindly direct, my lord, the tribunal to expedite it. Pardon, my lord?
What is your claim?
My lord, claim is for compassionate appointment. My prayer for compassionate appointment was turned down by the authorities, my lord, railway authorities.
Yes.
That order I have challenged before the tribunal. But that order I have annexed, my lord, at page 91 of my application.
So you have filed it a year back
Yes, my lord.
and you want a direction for expediting the matter.
No, my lord, this order was communicated to me on the when I have approached the tribunal under a content proceeding. Previously, I have filed an application before the tribunal. The tribunal passed an order to consider my representation. That representation was asked to be considered by the respondent authority.
Where is that order?
My lord, that order, my lord, page 78 onwards, my lord. But page 89, my lord, is the, my lord, the penultimate paragraph at 10, my lord. In the fitness of things, we would therefore direct the authorities to suitably ameliorate the grievance of the applicant, having failed to show that he does not deserve any consideration in terms of such and such memo. Let appropriate order be issued within 2 months from date of receipt of copy of this order. Lord, this was not acted upon. I have preferred, my lord, and contempt proceeding before the tribunal itself. In the content proceeding, my lord, I was communicated with this order in the year 2024 itself. Thereafter, my lord, since this is a fresh cause of action, so I have filed another application before the tribunal. The only why I have come up before your lordship is, my lord, presently I am aged about 56 years. My application is pending since the year 2006.
So is for the other side.
My lord, I have served, my lord.
Ask them to come, otherwise. Sorry.
My lord, may I
Have a
humbly
copy. Let me, the
Item number 5.
I've got the petitioner, my lord.
you have got the instruction.
My lord. No, she's in hospital. But
There is no instruction. She is saying I am ill. सुनान से करबत प्रार्थना है कि मेरी स्थिति पर विचार करने की कृपा प्रदान करें. He has not asked you to withdraw.
I think so far she could not understand whatever I have told, and also she was not in a position to understand myself, rather, my lord. That's why my lord's decision will be taken into myself. No problem. I shall not be in a position to linger this, my lord. No.
But since the written instruction is not to that effect, should you be doing that? That is what we are asking you. There is no specific written instruction, so can you make such a prayer? Therefore, we are asking you. If
No.
she is,
No, my lord, they have not given a specific instruction to regard to that, whether I shall withdraw it or I shall quit the matter.
so what do you want? You want to press it on merits? Then we can consider it later. Or if you want to withdraw, then come with better instructions. It must be specific. Otherwise, how you can make a submission that you want to withdraw?
My lord, may I kindly submit that? May I give some time, my lord, after vacation?
As prayed by the learned.
Item number 6.
We are the, so we are a petitioner. We have served the copy. We have come before the. Oh, ekta copy are done.
Government of India has filed the writ petition.
For the Union of India. We have come for the stay of the impugned order dated 7/7/2005 passed by the tribunal lordship,
Why?
because the respondent is still under the period of the punishment,
When the period of punishment is till which date?
1st July to 30th September
Of
25.
show us. Where is the punishment order?
Lordship. Punishment order. Yes, sir. 60. Lord, annexes P368. Page number 60, second volume, most probably. No, first one, Lord, 68, page number, charge sheet.
Sir, we are asking you about the punishment order.
Lordship.
Yes.
Findings, for 3 months, कहाँ पर इसका?
That lapsed in May 2025.
Uh, 71 and 72, Lordship.
72. Just
72.
read.
Last date of increment is the first July.
Lordship, the increment will start from the July 1st. So we are only concerned with from the first 3 months increment should be deducted. So that is 1st July to 30th September. Is number one. Number two, vigilance has still not given a clearance. Vigilance is still going on against him. Proceeding again started. There is a recovery of the dues for where he has unnecessary has.
Where is the order for recovery? Where is the order for
That
recovery?
is still going on, Lordship.
No, sir. Nothing is going on. This is the final order. This is the final order in the
Still
proceeding.
final order, he is still.
And final order is just withholding of increments for 3 months,
Lordship.
which lapse in May.
No, 1st July increment will start from the 1st July. So 1st July to 30th September is still is the in another punishment period is going on.
How can it be? The tribunal has considered, therefore we asked you.
Lordship, as per our rules, the service rule is there.
Show the rules. Everything has been, you have argued this before the tribunal.
No,
Yes, you have.
no, Lordship, we are not, but another team was there.
You means you are one and the same.
Lord, I make.
Whatever I am saying to the party, not to the learned council.
Lordship, I make.
Yes.
I make. Page number, page निकालो इसको. Lordship, page number 85. In our classification, control and appeal rules, Lordship, date of effect of the penalty.
Page?
Page number 85, volume 2. Hundred one, 102, 102. The penalty of withholding the increment takes effect from the date of increment occurring to the officer after the issue of the punishment orders. It can be effect the increment which was due prior to the issue of the punishment order, even though it may not be actually been drawn due to the officer being on leave
But
or
now-
other admin reasons.
Now even July is gone.
For 3 months, Lordship, the July, August, September, 3 months punishment of
Even that is gone now.
30th still continue.
What remains?
So how can give them before time?
So nothing
After
remains.
It can be matter if we heard after 30th, then we can.
No, even if we accept 102, you have shown us that only when the increment accrues, it can be withheld. We understand what you are saying. So now the increment has accrued and that has been withheld. So what remains? Now what remains? If due to this subsequent efflux of time,
Lordship.
issue has become infructuous. And he cannot object to that because he has accepted the punishment. So we'll just say that from the next month you will release him.
Yes, Lordship, after 30th we can.
What else can be? Yes. What have you obtained? Today is 20. How many days left? What do they say? On which date? So now, how can they do it contrary to the rules? See, we can go into the issue on merits. We don't know whether that will be in your interest. Therefore, we are saying, we can go into the merits. We can hear out the issue. But before we hear it out, it will become infructuous. Now, hardly 5 more days, 6 more days. So, what is to be done? You tell us how much time you will take after 30th September. Please give us the time.
Lordship, ek once. Lordship, there is one thing. After we can be after 30th, we are responsible for that releasing. But the vigilance clearance should be required for us. So that's why vigilance. After getting the vigilance clarification, we will release it.
No, you can. You have to release him in compliance of the tribunal's order.
Lordship, we are with the honor to the order. But technically, just that we cannot give within the punishment period. Still continue going on. No? Page number 8. After the 30th September, let them to clear the vigilance clarification. We are bound to release them.
Where have you erased the issue of vigilance clearance before the tribunal? Show us from the order.
He did not allow me to file the objection. The first day matter was disposed of. The first hearing, without hearing me, only one ground, there is no pending cases, there is no recovery of the
No opportunity of filing a reply.
No, my lord. This is the problem. That's why the Union of India has come before Lordship. This is the central government institution. A person is absent last 3 months.
Central
without
government,
any-
state government, or private party.
Lordship.
Opportunity, everybody is required.
Lordship.
No, you don't have
I
any
did not get-
special opportunity because of central government.
No. I did not get the opportunity to
So
file.
therefore, whoever it may be, central government is not.
Lordship. I'm not saying I'm not that. At least I should give an opportunity to file an objection.
But see his predicament now, he will be stuck up for nothing. We appreciate what you are saying.
Lordship.
That is very tenable submission that you are making, but unnecessarily he will be left in the lurch under your bureaucratic exercise. Therefore, we asked you to.
Our hands are also tied, Lordship. We cannot go beyond our rules and constitution.
No, but then you should be in a position to give a timeline that we will take 10 days, 1 week, we'll do it in 15 days. Something you should tell us. Because now vigilance clearance is just a formality. The punishment has already been given. So now it is just a formality. That they will give the moment you make the moment you withhold one increment, the vigilance should be given. Nothing else is there.
So we are the separate vigilance is a separate department. What they will do and what.
But you are raising a plea on their behalf. Therefore, we are asking you.
This is the normal formalities. I can, Lordship, I can.
Don't know, but that Therefore, we are saying, when you say such a thing, but they have not filed a reply.
There is some higher authorities are there.
Yes, yes, yes. Take effect. But without reply, just traveler without reply is good also. How the order can be sustained without an opportunity? That is the only thing. We are not on merits. You are not understanding what we are saying. So that is immaterial. What is it on merits? Are they entitled to opportunity? Or an order can be passed just on seeing the original application. And we can sustain such an order without giving even an opportunity to file a reply. Looking at the way the matter has been disposed. Unfortunately for you, they are not raising an issue of fact that yes, it has taken effect. But the point is what to do now? And if we ask them to file, if you ask you to appear and the matter is to be heard, then it will take further time. Hmm? For your release only. Let's see what they have said in the petition. In your petition, have you stated anything about vigilance clearance?
No. This is the part of our job. When a person is going from one department to another department, vigilance is clearance, salary should be clear from this. If there is any recovery of the money,
What salary?
no,
He
whatever.
is resigning, he will get nothing from you. Zero. Only his provident fund if he has something, which is his money.
You are not in the, you are the
And we don't know if there is a group insurance or something like that he will get. Otherwise, he will get nothing. So he's,
a person, Lordship, just try to
if
understand.
he is saying he doesn't,
Lordship, I'm saying a person is appointed in 2023 and after joining here, 5 months he is absent. So what the department will do? Why we have appointed a person for the department?
but that
For
issue is
this
not, that
person?
issue is not here.
Not clear before the tribunal. So that we did not get any chance in the tribunal.
But that is not an issue here. For that, you have already punished him. He is not saying anything about that.
Lordship.
Those issues are not surviving anymore.
Lordship, we did not get a chance to say anything before the
That is
tribunal.
all right.
Was state, yes,
So
just,
therefore, we are asking you, what do you want to say?
at least input order should be state.
For what? We are asking you, argue on merits. What is wrong with the order? Show us.
So, Lordship, there is the judgment of the, I'm relying on the Haryana, Honorable Justice Sanjeev Prakash Sharma and division bench, Lordship, is there. That if is on the punishment, is increment or should be already stopped. I'm just giving this.
So we have seen rule 102. It will be on the same line.
Lordship.
That only when it is to take effect, it can be withheld. That we have understood. So we'll allow you to.
After the completion of the punishment, then we another.
That is why we are saying that that is precisely what we are saying.
Lordship.
Why do you want to spoil his career prospect? You are only concerned with the whatever you have to withhold from his salary of September.
Lordship.
That you do it. After that, expeditiously you take steps for doing whatever.
Definitely. I am the only for a 3 months increment should be deducted.
Yes.
I'm grateful.
Why? Send for someone, ask them to see.
Item number 7.
I am for the petitioner, my lord. My lord, that service has not yet been completed, my lord. Kindly fix a date after puja vacation, my lord.
As paid list after the holiday.
Pardon. Item number 8.
Number 8, my lord, I appear for the petitioner late.
What happened? What happened in your case? Yesterday, which we are taking
Yes,
up.
yesterday.
What happened?
My lord, he has not given to join me.
Oh, yes,
And
Mr. Sen.
moreover, my lord, his salary is been stopped, my lord. Puja month, my lord, kindly see.
Just wait, let him. We have asked him to find out.
This matter, if your lordship, my lord, kindly recollect, when the matter was taken up on the first instance on the first day, my junior, my lord, appeared and said that the briefs just now, my lord, we received the brief, so we said that certain instruction was required, so time be, my lord, accommodated. Now, my lord was kind enough to pass an order that very good, till that day, no coercive step be taken with regard to transfer. Now, what happened? My lord, thereafter, my lord, yesterday the matter was taken up, second time. Now, my lord, yesterday, my lord, an affidavit filed, supplementary affidavit stating that the salary has been stopped, and my lord, a loan that was, my lord, prayed for, that has not been sanctioned, these are that. Now, my lord, first of all, lordship, kindly, my lord, hear me. With regard to that claim of the, my lord, that challenge to that transfer order, because I have not yet, my lord, obtained any opportunity to place my case, that yes, that this petition, no order can be passed on this, or should not be. I cannot say cannot be passed. I say no order should be passed in this type of petition when, my lord, the tribunal, though, my lord, disposed of the matter. And, my lord, kindly consider one thing. After all, this is a matter challenging a transfer order. Now, my lord, may I tell one thing? If you lordship kindly allow me, my lord, 10 to 15 minutes time today, I shall try to satisfy your lordship that no order should be passed on this petition because of the fact that the only ground which has been, or two grounds they have set out. One, that they, according to their
So
perception.
you want to argue the matter on
My lord,
merits?
my lord, because may I tell, because of the fact, now, my lord, he has not joined to
So
his,
you have filed the opposition.
my lord, not yet, because there is no scope till
So,
then.
so you want to argue without opposition?
No, I want to file opposition leading alert that dealing with the same, but with regard to
We are
interim
trying-
order, may I tell
Now
you?
interim order is already passed.
No, interim order only passed, lordship, kindly, my lord, look your lordship.
How can you argue on the interim order now? It is already passed.
No, interim order only passed till that day, lordship, kindly consider
Yes.
that on that day, instruction, my lord, I have had no.
Whatever it is, that is an order. Right, wrong, indifferent, that is immaterial.
My lord.
That is the order. It is to be complied.
No, so far is joining, there is no such order, lordship, kindly consider.
What does, that is not the point. We had only asked you about salary, about nothing else. If you don't pay him salary, that is a coercive action.
No, salary, may I tell? Salary, lordship, kindly consider one thing. Salary, my lord, there is, my lord, that the three parts. First of all, my lord, may I tell one thing? From the date of release, that is from, my lord, 11th of February, 11th of December 2024 to 23rd February 2024, my lord, no salary was paid, that is correct. Because of the fact, at that point of time, my lord, he, my lord, remained absent, or, my lord, did not join therein. After that, pursuant to order of the court, my lord, he joined to that earlier post, that is not transferred post, at Dhonekali, where he was there.
That is in initial proposal.
Initial post.
After which
So-
order?
After the, my lord, the High Court, he came up before the Honorable High Court. Honorable High Court said that very good, for the time being, for the 3 months, this stay is there, you join there, and in the meantime, you have to obtain an order from the tribunal, because you have already gone there, tribunal. If no order passed, then you have to join to your transfer post. Then he joined at Dhoniakhali, his earlier post. And from the date of such joining, my lord, the payment made, salary paid, except 5 days, except only 5 days because of the fact, in between 5 days partial salary disbursement, my
Is
lord,
he
did
getting
not
his
allow.
salary right now?
He's getting salary right now. Only thing, my lord, whatever the read court passed an order, the pay the salary this time and that time, everything paid. And the salary for
Today
the
he is getting salary.
today he's getting salary. 5 days, my lord, may I tell only 5 days period, my lord, that has not been paid because of the fact
No,
that
no, we are
the
not on
first
4 days, 5 days. We are
5
on
days,
whether
may
he
I
is
tell,
getting
5
salary.
days because of the fact I'm telling before your lordship that partial disbursement for 5 days, my lord, the system did not allow. We are trying our level best so that it can be done. But the payment has not been done for the period, my lord, before, my lord, passing the order by the read court when he did not join.
That we have
That
understood.
has not been paid. That is subsidy.
See, you are saying there is a gap of 5 days
My
in between passing of the interim order by the court in the earlier
Yes.
proceedings. That 5 days you cannot work because the system is not
And
allowing.
11 December 2024 to 23rd February 2024,
Yes.
salary was not paid because of the fact that he remained absent.
11 December 24 till
To 23rd December 2024, there was no court order. After that, he, my lord, knocked the door.
23 to 24.
Yes, 11 December 24 to 23 February 2024.
Yes.
There was no such order, and he remained absent.
25.
Because by
23rd
that
February
time, already he
25.
released.
23rd February 25.
Yes,
Yes. So after that he was being paid
yes,
itself.
yes.
And
Ba-
what is the
barring
position
the fact-
today?
Today, my lord, may I tell, after the release order, my lord, he said that we are not allowing him to join. Now, my lord, my contention is that, my lord, if your lordship kindly allow me, my lord, 5 minutes time. Now, my lord, on that very first day, my lord, we did not have any scope to say before your lordship anything.
How many times you will say that? This is the third time you are saying that.
But the two memos
You are
relied upon-
saying that you want to file opposition, and at the same time you are trying to argue about the interim order. Can you argue about the interim order which is already passed?
No, interim order was passed, my lord, because of the fact on that day, my lord, there was no instruction so far we are
So
concerned.
fourth time now you have said this. This is the fourth time.
Now, my lord, may I tell one thing?
Yes.
Now, my lord, my lord, I have to file an affidavit, no doubt, because dealing with the same.
Said not to take any coercive action. You ensure that he gets his salary, current salary. When it is heard, it will be decided.
But so far, he's, my lord, the joining to that post, lordship, the transfer post, it has not yet been stayed.
We have said not to take coercive action. You have to arrange for his salary from wherever. Unless you pay him salary, will it be considered that you are not taking any coercive action?
That is one aspect.
That is the only thing in the interim order, nothing else.
Yes. But so far, my lord, my lord, the other part, the main part of the order.
That we will
said-
consider. That will be considered.
So far, he's joining, lordship, kindly consider. He
You
has already
arrange,
released.
you arrange for his payment from anywhere, from his transferred place or his earlier place, wherever you want.
Because after having been released, my lord, no payment can be done
So
here.
you arrange it from anywhere. Don't stop his salary. That is all we are saying. We have said no coercive action. So therefore, that has to be complied. They are filing a supplementary affidavit saying that they are not getting their salary. He is
That
not.
is not correct. That I explain here and now. That is not correct.
When was his last salary paid? You have got
For
instruction.
the last salary paid, yes. Salary paid. August salary dues in September and paid. And the September naturally due would be.
He's being paid his salary, they are saying.
What he's saying, probably his instructing person is also not.
Hmm?
His instructing officer.
No, let him say whether paid or not.
No.
Not in this way.
September salary has not been.
September
not
salary
become
will
due.
be paid. If you have got till August, then you will get September. So then
Let me explain like knows the bit.
You should see, we are not going to consider anything other than salary.
Not been paid salary for the month of September, though all other employees excepting me in the same establishment have been paid
They are
salary.
doing it. They have paid till August, then why they will not pay for September?
And Millard, my learned senior friend was suggesting that Millard, since there was no order, I was not paid salary from December to February.
Leave those issues. Those everything will be considered.
Salary as my lord, you teach to observe, let them pay.
They are saying that they are paying it. Where is the issue? They said that till August it has been paid.
September not yet become due. I am told that September will be paid.
It will all be done. If it is not done, you move the vacation code.
No,
We'll
Malad,
see.
may I tell?
So no,
September, may I tell? September, because of the fact, may I tell? Because of the fact already released. Now, my lord, that they from my lord, these office, the salary cannot be paid. Then, my lord, he has to join there and the entire.
no, until August, how you are paying him? What is this, Mr. Sen? So you pay it in the same way.
September release হয়েছে আবার
You continue paying in the same way.
after the order passed by the tribunal. At that time, there was no release order. After the order passed by the tribunal, just a minute, sir. After the order passed by the tribunal, again release order passed here. And then he came up before this court.
So
And after release order passed here, oh yes, we have to comply. I am not on that. I am not. Have to arrange. Have to arrange. May I tell one thing? My lord, so far those memos are not applicable. My lord, only thing may I tell before your lordship, on the basis of those two memos, my lord, order was passed. My lord, may I tell, on that day we could not submit anything. In any event, this is maybe the fifth time I am telling before your lordship. Now, my lord, may I tell before your lordship? Now, my lord, in the meantime, if he does not join there in transport post and we shall going on disbursing salary, lordship, kindly consider one thing. Then, my lord, without prejudice to our rights and contention, lordship, kindly consider one thing. My lord, disbursement of the salary, lordship, kindly, my lord, kindly or pass an order that disbursement of salary during this period will be, my lord, without prejudice to our rights and contention in this writ petition, writ proceeding. Lordship, kindly consider one thing. Then, my lord, kindly, my lord, fix a date. Lordship, kindly, as early as possible, we shall well, at the top of the list. At the top of the list.
Item number 9.
May I please, your lordship?
196.
My lord, the petitioner hearing before your lordship, my lord, applied for compulsory appointment. His father, my lord, worked as Mazdoor under the PWD division of the Jhargram. my lord, the joint secretary of the state of West Bengal, my lord, declined the appointment as such on the ground that I have applied after 2 years. After 2 years. But my lord, kindly see, my lord, my date, page 21. My lord, it is the
For filing of an opposition.
Item number 10.
My lord, I am appealing for the applicant. My lord, this is my affidavit of service, my lord. I have served all upon the respondents. My lord. Matter is about, my lord, compassionate appointment. My lord. Father of the petitioner was an employee under the Kolkata Police, my lord, Group D staff, my lord, technical department, my lord. My lord, he died while he was in service, my lord. Thereafter, mother of the applicant, my lord, applied for.
When did he die?
In the year 2013, my lord.
13.
13, my lord. My lord, thereafter, my lord, mother of the applicant, my lord, applied for, my lord, compassionate appointment. And, my lord, subsequently, my lord, petitioner also, my lord, applied for the compassionate appointment, my lord. And, my lord, my prayer was rejected by the respondent authorities. Your lordship kindly come to, my lord, at page, my lord, 34, lordship. My lord, rejection order, my lord. Have you, lord, what you, my lord? With reference to the above, I am directed to state that the proposal on the above noted subject was taken up and examined in this department in the light of the notification number 251 EMP dated 3/12/2013 of the Labor Department, read with subsequent amendment made from time to time and the case records. It appears that the candidate has not fulfilled all the required conditions as laid down in the said notification for being eligible to be considered for appointment under exempt category on the following grounds. Grounds 1, the applicant Vibha Sadok has submitted a certificate issued by the Board of Secondary and Senior Secondary Education for passing secondary examination. The Class X level examination conducted by the board is not considered as equivalent with the Madhyamik examination conducted by the West Bengal Board of Secondary Education as per memo number such and such dated 9/8/2022 of the WBCHAC. Any test conducted by the police authority, if any, is not validated unless basic eligibility is established. Now, my lord, notification, my lord, it was considered by the notification, my lord, 151, my lord, EMP, my lord. And, my lord, subsequent notification has no connection with this, my lord. And, my lord,
The Board of Secondary and Senior Secondary Education.
your lordship kindly come to the, my lord, notification. I have annexed, my lord, at page 69, lords.
What is the notification?
Notification of 251 EMP dated 3rd December.
Forget about 251. What is this Delhi Board of Secondary and Senior Secondary Education? That is the only issue.
My lord, I have submitted, my lord, certificate.
You can submit anything.
And, my lord, it is, my lord, established, my lord, that board is established under the Indian Education Act under Article 19(1) of
Very
the
good.
Constitution of
Very
India, my lord. And my lord, I've orally submitted before I have challenged this order, my lord, before the Honorable Tribunal, and Tribunal pass order. And your lordship,
We are only asking you, what is this Delhi Board of Secondary and Senior Secondary Education? That is all. There is nothing else in this case.
Lord, earlier we have also, my lord, submitted, my lord, class 5 certificate, my lord.
So what?
Subsequently,
So what?
I have
What is the qualification that you are required to have?
my lord, notification is silent list, lordship, your lordship,
So
kindly.
therefore, anybody can be appointed. So you are not harping on this certificate then. You are only harping on the provision, whether it allows without this certificate also. What is your case? We are trying to understand.
Lordship, I have already submitted, my lord, class 5 certificate. Lordship,
So
kindly.
therefore, according to you, on the basis of class 5, you should be offered appointment. That is your case. Now then show us that a class 5 can be appointed.
Your lordship, kindly come to
Which EMP provides for appointment to a class 5 pass person?
Lord, at page, my lord, it is, my lord, group D post exempted category, my lord, tied in harness. Lordship, your lordship, kindly come to page 70, my lord. The notification eligibility, my lord. The family is indigent and deserve immediate assistance for relief from financial destitution. For this, any of the following two conditions is to be satisfied. The monthly income of the family, 90% of the gross monthly salary of the employee before death or premature retirement. The monthly income of the family falls below the minimum salary of Group D employee, or the minimum salary a lower division clerk in case of employee other than those belong to the Group D. The Milord, that about only, Milord, said, Milord, about, Milord, income, and Milord, about, Milord, qualification, Milord, the notification is silent, Milord. And your lordship, kindly come to, Milord, impugned order of the Honorable Tribunal, lordship. And Milord, subsequent notification which have been, Milord, referred, Milord, that has no connection, no nexus. Milord, at page, Milord, 82, Milord, 81, lordship. The bone of the contention of this case is on 9/6/2023, the Secretary Department of Home and Hill Affairs to the Commissioner of Police, Kolkata, issued a memo such and such, dated such and such, disapproving the case for appointment under the exempted category in the light of the guidelines contained in the notification 251 EMP dated such and such. The reason for disapproving the case for appointment is shown is that the applicant did not fulfill required condition as laid down in notification number 251 dated such and such, read with notification such and such. Milord, this notification has no nexus, Milord, of Labor Department, Government of West Bengal. The applicant contention is that these notifications are not applicable as the notification of the applicant is legal and valid. Finding no other alternative, the applicant filed this case for the relief as prayed for. It appears from the submission and document submitted that the appointment has submitted a certificate issued by the Delhi Board of Secondary and Senior Secondary Education for passing secondary education, the class 10 level certificate conducted by the board is not considered as
May I draw your lordship's kind attention, my lord, at page number 71, the part of that notification, that is, my lord, the 251 EMP.
At the bottom B.
Yes, see.
In all respects.
Yes.
Yes, see, you are correct.
Applicant for compassionate appointment should be eligible and suitable for the post in all respect under the provisions of the relevant recruitment rules.
Yes.
And
yes.
then relaxation is something else. Then the recruitment rules is, my lord, it is with me. Lordship, kindly see the notification of 5th May 2009. My lord, I have 2 copies. Lordship, kindly, my lord, the super educational qualification. I think, my lord, the 6, clause number 6. Clause number 6, that the minimum, there cannot be that there is no minimum qualification. Minimum qualification is, my lord, prescribed therein. Clause number 6. This is, my lord, the recruitment rules with regard to Group D, minimum qualification, clause number 6.
Seventh pass,
8 pass.
8th pass
8 pass. According to him, no qualification
can be considered in 5th pass.
This should be followed.
Yes,
And thereafter, your lordship, kindly come to me, Lord, at page 82, lordship, Lord, last paragraph. The tribunal also finds that no notification stated by the applicant.
see, just now you have said, we asked you what is your case. You said you are entitled to be appointed on being 5th pass. The rule says below 8th it cannot be done. So what is your submission? Why should we read the order? What is the
I've
point in
already-
reading the order?
Subsequently, I have increased my millet qualification from.
Huh?
I have increased my qualification.
You have?
Increased my qualification,
So
millet.
at the very outset, we asked you whether you are relying on that certificate. You said no. I want to rely on my 5th pass. Now you are saying that certificate. What is that certificate? Which is the authority issuing that certificate? You have not shown the tribunal. So what is wrong with the order then?
Milord, that
You have not been able to establish that it
that
is a
milord
valid certificate.
board, milord.
Huh?
Milord, that is valid board,
Where
milord.
to
Milord,
establish?
Which
We don't know.
milord, I shall file milord supplementary affidavit, milord.
What supplement?
What supplementary? When you have not filed before the tribunal, how you can file it
Milord,
here?
we have submitted, but we could not file milord document, milord. Milord,
Whatever you have filed before the tribunal, beyond that, how anything can be considered? What is the infirmity in the tribunal's order? We are here to see that only, not
milord, that
everything.
infirmity is stated, milord, here. Milordship, kindly see, milord, at page 82.
Tribunal
Nothing.
specifically
Nothing.
mentioned and recorded.
We have seen,
documents
we
to
have had the
satisfy that
occasion of seeing this board's
document
degree
that the
earlier
board-
also.
board
Therefore, we
exists.
are asking. At
Milord,
least I have had the occasion to see that whether this
milord,
board
all
exists
the
or not.
certificates were annexed, milord.
There
and
may
milord-
be.
And milord, what milord more to submit? Milord, that is the ultimate consideration, milord.
Did you apply for relaxation?
Milord, no, lordship.
But see, there is, if I allow,
Both of you will argue.
Now.
Give it to him.
but see, there is a similar observation of this court. I have gone through the order of this court, and I find that in case number WPST 80 of 2025, Sri Manoj Kumar Das versus the state of West Bengal. In that case, Kakoli Datto appeared for the petitioner. The petitioner is an applicant for compassionate appointment. His father died while in harness, serving in the office of the superintendent engineer, Northern Circle PWD at Malda. There is no dispute that application was made for compassionate appointment within time and on the pro forma prescribed. The claim, however, has been rejected by an order 20th September 2022 issued by the Joint Secretary in Public Works Department by assigning a reason that the petitioner was lacking in the required educational qualification for the Group D post. The rejection was put to challenge by the petitioner by filing OA application before the West Bengal Administrative Tribunal. The SAT has accepted the rejection as a valid rejection in view of the fact that is not in dispute that the petitioner was in class 4 passed candidate, whereas the minimum educational qualification is required for an appointment to Group D post was class 8 pass. The learned counsel for the petitioner submits that there are provisions in the scheme for compensatory appointment enabling appropriate authority to relax the minimum educational qualification for appointment to Group D on compensatory ground but not eligible cases. It is submitted by the learned counsel for the petitioner that the government servant left behind his wife, one daughter and 2 sons, all of whom were educationally qualified for regular recruitment to the Group D post. It is further submitted that the several documents have been submitted as required in support of the income status and family, including income from any other sources. From documents submitted, the penury being suffered by the family of deceased employee is apparent, However, the authorities have not considered the petitioner for grant of relaxation in the minimum educational qualification in terms of clause 6B of the notification dated 3rd December 2013. Mr. Mukherjee, learned AGP, submits that the authorities have rejected the claim after due consideration of all the documents submitted by the petitioner, as apparent from the communication sent from the office of the superintending engineer, Northern Circle PWD, to the Joint Secretary of the Department 28/10/2021. Upon considering the notification dated such and such, the communication relied upon by the learned AGP such and such, we therefore find the order of 28 para number 6, 28 September 2022 to be unsustainable. The same is quashed. We direct that this is the same bench order, Lordship. I find I have searched so that
What did we ask you when you started reading the order? What did we ask you?
this can appropriate for my group D post. If
What
if
did
it
we
is
ask you, sir? Before hearing what we had asked, you started reading the order. We asked you, did you apply for relaxation?
Yes.
You started reading the order.
Yes, I apply for it.
When you have applied for relaxation, show us.
Apply করেছেন relaxation এর জন্য।
So from group D post, I have applied. Actually, they have sent the order actually.
You understand anything we are saying, or you don't understand anything we are saying? Third time we are asking you, did you apply for a relaxation? On the first time you said yes, second time you started reading the order, and now you are saying something else.
No, Millard, sorry, Millard, relaxation was not applied.
So say so. Why you are making up things, wasting time unnecessarily? Only if you apply that can be considered. If there is no other eligible person, there are so many conditions, it has to be considered according to that. They don't have discretion to give it to everyone. So you apply for relaxation, they will consider. What else can be done?
Obliged.
The petitioner's application for compassion.
Item number 11.
Item 11, my lord. Item 11, my lord, I appear for the petitioner.
The state respondent. No, Millard, tribunal has passed. No order has been passed by the tribunal. Only tribunal said, Millard, matter has been fixed on 6/1 for admission here.
Well, the matter relates to resignation, my lord. There is a rejection order.
I am
And I
not-
challenge the rejection order of the tribunal.
Not on that. Millard, kindly take the order once. The tribunal said, Millard, Mr. Ghosh and Mr. Swansky, learned advocates on behalf of the applicants are present. Let this matter be fixed before this bench on 6/1/26 for admission hearing. Now what? Nothing has been decided. Millard, tribunal has fixed this matter on 6/1/2025. They said, Millard, quash this order. Millard, but quashing, Millard, nothing has been decided. Only thing tribunal said, we will have this matter on 6/1.
What is the impugned order before the tribunal?
Well, page 64.
Resignation Millard applied for and that has been turned down.
Now you tell us whether you should be generating such litigation unnecessary, or you should be taking some.
since they have on 6/9, they have filed this writ petition before the tribunal. The
We-
order
wait.
passed away, my lord, sorry. The order passed on 11/7/2025.
And
So they are sitting 2 months.
11/7.
11/7/25. They have filed the way before the tribunal on 6/9/2025.
the
They must have annexed the earlier orders passed by this court.
Yes, my lord. But
prior
Now just tell us, you are the state, therefore we are asking. There are repeated decisions of the court on this point rejecting the same claim. Does it behove the state authorities to take such a stand?
my lord, as of now, my lord, we have not taken any stand because of the reason, my lord, the matter has not yet been
No, we are asking about the rejection.
rejection. Yes.
No.
No, rejection
Is
has
does it lie within your discretion to raise this issue, ignoring the repeated pronouncements of the court? Or you should take appropriate decision.
But my lord, as my lord,
It's not meant to.
A person who resigns, he forfeits his entire past service. Can you compel anyone to work? We appreciate what you are trying to say. We have already considered that. In fact, I was also a party to one or two of the decisions. This does not lie in your mouth. You cannot raise this issue. He wants to go. He wants to go.
the thing that has been mentioned, what I find is, my lord, that he's a doctor, my lord, and in that hospital, my lord, there are insufficiency of the doctors. If you go, my
That
lord,
is why we are saying the same issue. There is nothing new.
only things in other matters, my lord, where the lordship has decided, my lord, the tribunal has passed some orders. Here, my lord, my lord, the only thing is that
We understand what you are saying, but today, in absence of tribunal, whether you can raise this issue.
but in this writ petition, my lord, nowhere it has been mentioned that the tribunal
The
is not
resignation
functioning.
has not been challenged.
No, they have come up. We didn't know. Yesterday, in some matter, they showed us the notification. 8/9, perhaps a notification of 8/9.
Deep level, yes,
You know everything. You
I
know.
know, my lord, Lordship deal with so many matters.
So therefore, we are wondering why you are taking such a stand in every matter. Why can't?
And if his lordship takes the, my lord,
Prayer.
prayer, my lord,
Prayer is
of
still
the
prayer
my
is
lord,
page
my lord, page 40, my lord, a mandatory order to issue, thereby setting aside quashing the rejection order.
page
No,
20.
rejection order in the way, my lord, page 40, my lord, 11/7/25, so and so. 11/7, after 2 months, my lord, they have filed. And
And here-
in this writ petition, my lord, they said, my lord, the setting aside of the order, which has not yet been decided anything, my lord, only date has been fixed. They are a, my lord, kindly see, my lord, only, my lord, they said, my lord, that impugned order dated 9/9 so and so shall not be set aside or quashed in the event no cause is sufficient cause. The tribunal says, my lord, the matter has been fixed on 6/1. এতে যাবো বি যাচ্ছি না তো আগে এ থেকে বিয়ে যাবো আগে উপর থেকে যাবো নিচ থেকে বলে উঠবো না
Yeah.
Puttu. Puttu, political party to 79. Puttu first political political. Puttu. 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 Political party. Yeah, 8.
Now you see page 78.
So I have seen that. Only things, Milord, the basic difference is, Milord,
Here are
in those
results.
cases, Milord, at least, Milord, some findings are there, Milord, and accordingly, Lordship has. Paragraph 17, Milord, kindly, before concluding, we must so and so during pendency of the instant proceedings also, the Principal Secretary, Department of Health and Family Welfare has recently passed a reasoned order dated 9/1/24, refusing the petitioner's request for resignation on the same ground of acute shortage of personnel and so and so, so and so. Apart from that, here, Milord, the Principal Secretary has not Milord, passed anything. So, Milord,
No, we have said that reasoned order is nothing.
yes, sir.
It is a non-est because it was not even as there was nothing in it was not even having any details regarding issue, and it was not by the appointing authority. So that was no order that we have not considered. It was not authenticated in accordance with Article 166. You take instructions and you, in light of this order,
Or shall I file a short report before his Lordship in this regard?
what report you we expect that better reason will come, because otherwise if we are having to pass the same order in every case, then in some case we have to say something, some consequence will have to follow. Therefore we are asking you to take some instruction in this matter. An issue arising for consideration in the present case
Date of service, my date at the
affidavit of service is taken on it. See, you are also there to advise. This should not be, this is unwanted.
Absolutely right. Continuing litigations. Yes. Lordship, get.
Call.
Item number 12.
Item 12 also, my lord, I appear for the petitioner. Issue is same. Where your lordship heard Mr. Shen, learned senior advocate, appearing for the state. Now he has to make a submission, my lord.
May I tell you for a lordship, my lord, kindly pass the similar order so that I can, my lord, it would bail me out also so that I can
All right.
communicate it,
Same order in this case.
so that I can communicate it.
WPST is on record in this case also.
Yes, also.
Yes, my lord. Yes, my lord. That is on record, my lord.
My lord's order that is annexed.
My lord, your lordship has fixed the
Medical college is different.
We are fixing it 1 week after the holidays.
as well, deeply.
But 1 or 2 weeks, don't my lord. 1 week after.
Deeply, yes, my lord.
हाँ जो उसमें रेफरेंस है ना WPST 34.
Today we are almost on the verge of the closing of the High Court, and then my lord, 1 week after, lordship kindly make it 2 weeks after both the matter. So
All right, 2 weeks is reasonable. Yes, 2 weeks. Both cases 2 weeks.
in both the cases, 2 weeks. In the meantime,
We are being reasonable.
always, always, always.
Deeply, yes, my lord.
Item number 13.
Item number 13, my lord, kindly take it up after vacation.
After the state, lordship.
Trade
My lord,
after holidays.
sir, one clarification, my lord, I may have heard wrong. Item number 8, the interim order was extended till disposal.
Which
Item, that transfer matter, Mr. Bhattacharya was at.
where is the question of the extension?
But up to 24th, your lordship kept the interim order. Other 26 up to tomorrow.
Oh,
That
then
will
it
kindly
will-
extend it till disposal. Well, my other side is there.
This is not this,
Not
this
this
matter is. not
item
this
8.
matter.
no, we will record extension till 2 weeks after the holidays.
Yes.
Yes,
Okay, good.
we are making it clear, Mr. Sen. Which matter? Which item?
Item 8, item 8.
8.
Item 8.
Item 8. The earlier interim order stands extended.
After vacation. After.
Yes, yes.
13. Lordship.
You have paid in 13, right?
13 I have read time.
Lordship.
After vacation.
I have not understood this case.
Item number 14.
Lords, item number 14, my lord. I am before my lord for substitution. I am not by abundant caution made an affidavit of service also with respect to intimation of yesterday's order as well. Yes, may I hand this? Lord, may I say this? The respondent number 7's Vakalatnama is not on record. Number 1. Number 2, the aspersions have been made now that to serve a member who was a member of the Bar Library Club who cannot possibly file a Vakalatnama. My lord, kindly pardons me for saying all of this, but these kind of dilatory tactics are being adopted only to delay the matter. Kindly takes my application, Lord, Can 4 and Can 5 extremely innocuous. Service or no service will not cause any impediment to my learned senior friend. May he indicate who is appearing for? He says the respondent number 7. May he kindly show the day on which he has entered appearance or filed this Vakalatnama. None of the same are on record. I approach each and every individual on separate occasions. They come and say, I have received, don't worry, we'll have the application allowed. Now they come and pop up in court and say that we've not received an application. Not very well. May I serve my own copy to them? They can see I'm moving, I shall move from my own page. Kindly, Miller takes the application.
So all respondents are there.
I do not know. Some other day, someone else will come and say that they are for someone else. This is the tactic being adopted.
2 to
Kindly take the appearances.
2 to 6, 9, and you are for 7.
I'm for 7.
Kindly take the appearances on the prior occasions. There have been a collective appearances. আপনাদের injunction.
Why substitution? Why you are, what is the problem with substitution?
My lord, kindly allow this substitution application.
Who is opposing the substitution?
No, nobody is.
Are you opposing the substitution petition?
No, my lord, we are not opposing, we are not opposing. But a copy has just been served to respondent number 7.
Application was stay में.
Can number
बोलते
बोले नहीं?
जाओ ना.
Can 4 and can 5. Can 4 had been 5.
one by one.
Yes. Milord, will kindly take can 4, Milord. It was for substitution of the respondent number 11. My lord will find the death certificate at page 14 of the respondent that I seek substitution. My lord, I have pleaded in paragraph 7.
Respondent number 11 has expired.
Yes. The
Joydev
death cert-
Banerjee.
Yes. The
His legal heirs are.
at paragraph 7, my lord will kindly take
Swapna Banerjee है कि
and 4.
Joydev Banerjee is substituted. Para 7.
দেখো না কি বলছো. Can 1, can 2, can 5 তো আলাদা রে.
Who has expired?
Respondent number 11, my lord.
Swapna Banerjee.
No, my lord.
Yes, sir.
Ganga Banerjee.
Yes, Swapna alias.
Swapna Banerjee. Yes. I am
Swapna.
sorry, my lord. The alliance, my lord, I was not aware of at the top of, at my cuff, my lord. Kindly,
And her legal heirs are Joydev and her son,
yes,
and one only.
yes.
No, Pranav Kumar. No, Jaydev. There is only one legal.
Just join. Just join. ওটার জন্য
Which?
Respondent number 1
that is can 5.
is since diseased.
That is also filed. Both he has filed. That is a separate can.
Yes, my lord.
Can 5 is for substitution of the respondent number 1.
Separate orders. The first thing is common order.
Sorry, counsel. Be specific. Why are you saying such things which are not relevant at all?
Now see the can 5. Kajal
Can
Chatterjee.
five.
Kajal Chatterjee is
One.
Kajal Chatterjee.
Yes.
My lord.
To be substituted by
Kaushik and Sukanya.
Yes.
Kaushik Chatterjee and Sukanya Bhattacharya.
As your lordship.
Who were representing these persons? 11 and 11, respondent of 11.
9,
Who was
10.
representing?
I'm representing 9, respondent number 9 and 10.
11 who was representing? Nil. Okay.
পুরো অর্ডার কোনো
Lord,
Deeply obliged, my
my
lord.
lords, I used to keep it on the 7th of November. My lords have been, would it be any day barring the 7th, or I have a, any day barring the 7th? I have to take my grandmother, my lord, for a yearly checkup. Could it be 8th, could be 5th, any day. Ali,
Other than
Chhoy, 8, 11. Extremely obliged.
Deeply obliged, my lord.
Deeply obliged. হ্যাঁ দিচ্ছি দুটোই
My lord.
Item number 15.
My lord, in item number 15 and 16, my lord, Mr. Saurabh Mandal is appearing on behalf of the Chittaranjan locomotive. His mother is suffering from cerebral attack, my lord. Kindly let it be, my lord, after vacation.
we are informed that and give the name of the learned advocate who you said is unwell. His name also you. Your name and his name both.
Fifteen and 16 both. Analog.
Item 17.
17, Your Lordship, I appear on behalf of the state.
And for the petitioner, my lord.
The matter, this matter for appointment on competition appointment on special circumstances. Special circumstances which was promulgated by the state during the period of COVID-19 pandemic period.
Position has been filed.
Your Lordship, the pleadings are complete.
Pleadings are complete. Item 18.
18. Your Lordship, I am appearing for the state, but the answering respondent is
I'm
the
appearing for the
PSC.
petitioner, my lord.
I am appearing for the state, but
Yes,
this is that matter where Your Lordship was
Good.
pleased to inquire where did the petitioners get the answer scripts from the other candidates. Miss Piali Shengupta is appearing for the PSC.
May
She's
I
not
file
here.
this supplementary affidavit, my lord? Because from where I get that information, my lord, that's the
The copy may be so.
information, my lord.
The copy has
My
not.
lord, yes. Actually, other candidate got by that, yeah, and one WPST 43 of 2024, which is before my lords also, I got that copy from that writ petition. My lord, but that candidate,
How one person can get information of another person?
My lord,
Therefore, we were wondering.
with the best of respect, my lord, recent Supreme Court says that no, in the public employment, you can't say this is the information of another person. Otherwise, my lord, it is not possible to ascertain whether the less meritorious candidate got appointment.
No, but it depends on what information you are
Yes,
getting.
yes. But
The marks of someone else who is not a party, how can you get it?
my lord,
If they are a party, then you can get it.
no, my lord, with the best of respect, my lord, subject to correction, my lord, the recent Supreme Court position is that if my lord wants that, I can bring that there to you. The under Right to Information Act, my lord, that is not a third-party information in public employment. In the case of public employment, if I want to gather information of somebody else, my lord, I could get it. But in the instant case, my lord, the other person information which is annexed in WPST number 43 of 2024, which is before my lord, and that
matter is also before us.
Yes. Now this is disposed of. Sir.
Disposed of.
Yes.
What is the number?
WPST 43 of 2020. I also bring that that writ petition also. That is it is annexed with that writ petition, and that person got that information through Right to Information.
We'll hear it after.
I'm appealing for the Public Service Commission.
After holidays, can't be taken up now.
My lord, but
Lordship,
this person
to take instruction regarding the right to information.
No, that they have already given.
already, my lord.
You have served her a copy.
Yes,
Give them copies.
WPST.
Supplementary affidavit is being.
Well, that is remanded back to the SAT.
Purnisha Ghosh.
Remanded back to but they directly filed the petition. And by instant cases here, my lord, already this petitioner number is matched with the last selected candidate, my lord. And one matter, my lord, from the SAT order, it is evident that half number was awarded in case of one.
Since we have adjourned it, let it come. We'll consider it.
Because every party is appearing, my lord, if my lord wants, my lord, as an interim measure, my lord.
No interim. What?
My lord,
All the
appointed expert, nothing more, nothing less.
Nothing, sir, nothing.
But in the instant cases, my lord,
Next case.
as my lord.
Item number 19.
Grateful, my lord.
When matter is case 17.
And 19, I am appearing on behalf of the respondent. The petitioner has completed his argument.
Huh?
Petitioner, an advocate for the petitioner, has completed his argument, perhaps. And this is my turn to reply to that.
After vacation.
Yes.
Lordship, one request, Lordship, interim order expire, Lordship, kindly.
When?
The interim order expire on 28 August, Lordship. On the last order.
What is the interim order?
11.
One was vacant.
That will be there any.
Extend the order for
29th of
Vacated in August. And therefore, without any application, how can it be extended?
Lordship, already reimposed the order.
Why you have waited so long?
That are running in the list. But
So you should have taken steps. Probably nothing has happened right now. The matter is adjourned for.
But since I have got the instruction, I think that order should not have been passed.
20.
My lord, my senior is engaged after vacation.
Yes, as prayed.
Twenty-one.
None appears. This is the other side of the Pujali.
Twenty-two, 20,
23.
23,
23, Your Lordship, I appear for the state.
None appears for the writ petitioner.
Item 23, I'm praying for not this week, Mahal.
As prayed 23 में कर देना, as prayed after the Pujali days.
Onindo Bhattacharya. Onindo Bhattacharya. Petition.
You are appearing in 23.
23.
Give an appearance, otherwise next case has been called, your name will be printed and then to be mentioned.
Your Lordship, 24, I'm appearing for the petitioners. Your
Yes.
Lordship, this is a defense matter. I had to file my paper book. I'll file it in the course of the day and let the matter appear after the vacation.
There is a direction for paper book.
Your Lordship, we have served.
Item 24.
Your Lordship.
It is submitted by MS.
item 25,
Yes, in this matter, I am appearing for petitioner.
My Lord, I am appearing for the respondent, my Lord. My Lord, kindly take it after vacation.
As jointly prayed.
My lord, I am praying for liberty to move this matter before the vacation bench, my lord. Difficulties, my lord, the petitioner has been retired, my lord. He is not getting his settlement dues, my lord, is even pension, my lord. It's in the motion stage, my lord. New motion stage, my lord. Matter was, my lord, delisted, my lord. It's in the department, my lord. If it can kindly be, my lord, heard in the vacation bench, my lord. It's running from pillar to post, my lord. My lord, I'm grateful, my lord. I am grateful.
লিভ ছাড়া কি করে হবে গো দাদা? ও দাদা, দাদা লিভ ছাড়া পেছনে কি করে ফাইল করবে? ভ্যাকেশন বেঞ্চে যাবে কি করে? ফাইল করে দিলে দিতে পারবে না।
Audience side, district matter, and under heading to be mentioned, cell number 1 and 2, Sajul Datto.
My lord, I appear for the appellant. Our notes are ready, my lord. Maybe hand it up.
Filing the notes on behalf of the appellant. Mr. Mitra is leading.
So your notes are not here right now.
Lordship,
Yes, they are here, my lord. They are here. They are here.
There's a written notes on behalf of respondent number 6.
You already submitted.
There is your lordship directly serve copies of them. May I also have a copy?
Ma'am, may I also have a copy of the?
You should give each
Yes,
other.
yes, of course, of course. I'll immediately, my lord, immediately I'll give
For
copies
these
to
things,
both
you
of
don't
them.
need the court's order.
I shall serve my written notes on the appellant within the.
Ensure these are basic courtesies. What is there to direct?
I've served all the. Well, he has given me. I hand over a copy to him within the course of the day or by tomorrow.
Yes. Very
Grateful.
well. Where is it? Show us. All right, written notes and submission. Written note of submissions earlier.
Your lordship, a very happy puja vacation.
Yes, wish your lordships all the very best for the puja.
Same to you all.
Grateful, madam. Grateful.
দিদি তো দিলাম এসএন মিত্র হ্যাঁ এসএন মিত্র পেয়েছে ওটা দিলাম জজ সাহেবটা উঠবে তো জজ সাহেবটা উঠে যাবে বোধ হয়
Item number 1. Item number 1 for judgment.
Malas.